Share space. There we go. Now we're officially recording. So good afternoon, everybody. Welcome to our first masterclass series for 2026. Yay. We're back. We're back at it. We're back to work. Work has resumed. Like we've not been doing a lot has already happened this year in the AIM world. But this is our official first masterclass for this year. And we're excited to get back going because I think in terms of just impact opportunities, the masterclass has been that vehicle for us. And so grateful for the privilege to continue. And who better to get us started? We couldn't have started with a better opening than our own attorney Uzo with the way 2026 has been. Well, 2025 into 2026, you've almost been very prophetic in in all of in all of the things you started telling us before and the warnings and all of that, and now everything is at where it is. So conversations around immigration are very relevant today. And again, grateful to everybody who is on the call now, even if it directly doesn't pertain to you. You're learning so we can keep informing our community, and so that's also part of the objective of this session. So thank you all for being here. Like we always say, and with every masterclass, please, everything shared is still do your research. Still, it doesn't replace proper legal consultation and proper, due diligence. And so this is attorney sharing from her own wealth of knowledge. There might be things that are unique to you that you might need to have other, further conversations, and that's what we would recommend. But with that said, it is my joy and honor and privilege to welcome to the stage our favorite attorney Uzo.
Thank you
Welcome.
so much, Namdi. That was such a nice intro. Hello everybody. It's good to be back this year, and things are going on. Everybody is
Yeah.
moving. I can say from just going in, it's been tough for immigrants, but just like we thought it was going to be, and I guess in a little case, in some cases, tougher than we thought it would be. However, just like I promised, immigration lawyers are always up to it. And these days, even civil rights lawyers are up to the task too. So they're suing, getting results. And one big thing I talked about last year was if you remember, immigration courts fall under the executive. That is to say, they are found under the presidency because they are really administrative law judges. Immigration Court is an administrative law tribunal under the Department of Homeland Security, I'm sorry, under the Department of Justice, which is under the Attorney General who works for the president. So they are Article 1 courts. Now, Article 3 courts are the real judiciary courts. So the way appeals go is inside the US, I'm sorry, the DHS, where we start in immigration court. There's that court, and then there's the Board of Immigration Appeals. And you appeal from the immigration court to the Board of Immigration Appeals. And once you do, after that, if you need to appeal further, you transition to the judiciary, which is the Article 3 courts. You go straight to the um, US Court of Appeals for the circuit where you reside. In some cases, you can also ask for review in the US District Court where you live. So at that point in time, you're now dealing with Article 3 courts, which are real judicial power courts and not executive branch courts. So, and those Article 3 courts, they are very big on due process and just following the law the way it's meant to be. So that once things, and people tend to appeal from the BIA to the Article 3 courts or petition for review. And once those courts start getting clogged up with cases out of DHS, they don't like it because they're seeing a lot of due process violations and they don't like it. And just being clogged up with cases that should have been decided better, I guess for a better way to phrase it. So that's what's been going on. So ever so often we have pearls, little pearls of decisions in all these hard times. But what's been going on lately since Mr. Trump came, we remember there's the partial ban, starting with first was about 19 countries, and then the 10 countries were added, and today we have 79 countries banned from the US. Some of them partially, some of them fully, as in nobody can come. For us in Africa and the African diaspora, I'll tell you that I'll read out to you the countries that cannot come. No immigrant visas from those countries, no non-immigrant visas from those countries. I guess starting from the day of the ban. Chad, Equatorial Guinea, Eritrea, Libya, Haiti, Somalia, Sudan, Yemen, Burkina Faso, Mali, Niger, Sierra Leone, South Sudan. The way it is now, by executive order, Mr. Trump has said that people from those countries may not come to the US. They cannot come as immigrants, that is to say, green card holders, and they cannot come as tourists or business people. They just can't come. He has stated his reasons for the ban. Some of them are more of security type reasons or whatever, but for reasons better known to them there, they say people from these countries cannot come to the US. However, anecdotally, from what I've heard, because in all these things, there's a lot of lack of clarity, and people are kind of trying to do things and see how it's going to work in each case. Anecdotally, what I found out is that if you have, let's say you have a pending immigrant visa application interview, which is already at the US consulate in any of these countries, what will happen is this: they will invite you for your interview and you go for your visa interview. But at the point of your visa interview, you'll be given a sheet of paper with a denial based on the Immigration and Nationality Act, Section 221F. So you get a 221F denial. So what is 221F? 221F is the section of the US Immigration Law and Nationality Act that allows the president to insert himself into in using immigration, I'm sorry, using his executive orders, I guess, executive power to put himself into the process of immigration, and that means that he can make certain rules. So that particular provision of the act foresees that those rules, those executive orders are temporary, are most likely temporary in order in nature. So that if the president feels like the circumstances have called for it, he can withdraw the orders and resume processing. So that being the case, people are still being scheduled for interviews for their immigrant visas, especially. And um, when they go there, everything is complete, but they're given a 221F denial, meaning that when you hold on to that and if and when things change, you can come back and you should be, I guess they'll run the checks again and you should be able to get your immigrant visa and come to the US. For the non-immigrant visas, that's the tourist visas, the business non-immigrant visas, I think the way it's worded, it means they can't come at all. Nobody really can come from any of those countries. I think about 12, 13 countries I just listed out of Africa and the African diaspora, okay? Then there are some countries which have a partial restriction. Again, for those countries, now for those countries, I think anecdotally, the immigrant visa processing is not affected. However, and then the non-immigrant visas, remember, immigrant visas pertain to green cards. Non-immigrant visas could be temporary work visas or education visas or just your regular tourist visa, which we know. In those cases where there's partial restriction of visas, how it's working out is that non-immigrant visas are not being given. Certain non-immigrant visas, non-immigrant visas from the business side were not mentioned. So that tells us that the L visas, the E visas, they should not be, they are not affected because they are business type visas. The executive orders state specifically that the diplomatic visas are not affected. That will be the A visas and the NATO visas. They are not affected. But what is for sure, the visas that for sure affected for those countries are the B visas, the tourist visas, B1 and B2, the F visas for students, the M visas for vocational training, and the J exchange visas. Those ones are affected in the countries that have the partial bans. Again, I personally think there's a lot of lack of clarity in the whole thing. Although I think the executive order may insist they've told us how it's going to be in exact terms, but I see a lot of lack of clarity. And then sometimes there's entry issues. You can have that visa, everybody is feeling a little empowered, I guess, and you can have the visa, get to the airport, and you may have a rough time. But the guidelines they gave is this. The government says that if you already have if before the date of January 16th, you were already given a non-immigrant visa, that is to say, or an immigrant visa. You went there, you got your non-immigrant visa. Let's say you got your tourist visa on December 28th, 2025. You should not be stopped from coming to the US. You got your visa, let's say the last work day of last year, I believe was the 30th, if I'm right, was the last work 30th. Let's say you got it 30th of December 2025. You got if your non-immigrant visa was your tourist visa, your student visa was stamped in your passport. You're not, no problem. You'll be given back the visa and you shouldn't be stopped at the airport just because of the ban. Again, I say it's not clear, but they also say that if you already have those visas and you're inside the US, you're not affected. You'll be allowed to finish up your period of stay. So for instance, let's say you got a visa on 26th of, let's say 27th of December 2028. I'm 2025, and you are now inside the US already. You flew that same night you got the visa. You're allowed to, and then let's say you came into the visa, you are into the US, you're allowed to stay for 2 weeks, 1 month. You're not affected. You're going to be allowed to finish up your stay. What they didn't say is about people who came in but now want to extend their stay. So let's say that person who came in December, having been given a visa in December, he came in. Let's say a Nigerian, because I know they're subject to this partial ban. You got your visa before January. You came into the U.S. and upon coming to the US, now you want to extend your stay. I don't know how it will work, but I am thinking that you may be able to extend your stay. Of course, just considering the general atmosphere of the country, it's actually possible that your request for an extension of your stay may be affected. You may meet somebody who doesn't feel like it and it will be denied. But if you're outside the US, as of today, as from that date, I believe it was January 16th, as of that date, you're not going to be able to get a non-immigrant visa, a tourist, except if it's a B visa. I'm sorry, except if it's a work visa, like the L visa, like the H visa, like the E visa. Of course, the H already has its own little issues regarding the $100,000 fee, but I'm not going to talk about that today. I guess that I'm thinking that bears having its own little discussion on at a different time. Okay, but if you have let's say how you're from Senegal, you already have you need an e-visa to come into the US. Based on this executive order, you should still be given the e-visa because you're not subject to the total ban, you're just subject to the partial ban. And that partial ban does not list the business visas. It just lists the student visas. See what there are more things they said. Okay. I'm going to ask for 2 seconds. I'm going to black out and I'm going to pull my paper again. Hold on. Okay, so we continue. Also not affected by the visa bans. If you're people who are, I've already talked about diplomatic visa holders. Also people who hold dual nationality. So let's say you're a citizen of the Gambia and you're also a citizen of the UK. You are not banned because you're going to be, you're not, you will not be subject to the total ban, I guess, and even the partial ban because you have a visa from another country which is not subject to the ban. For instance, you're from the Gambia, which is subject to the partial ban, but you also have a US passport, I'm sorry, a UK passport. You're going to be able to come in because you can use your UK passport to come into the US. You're fine. Let's say you're from Senegal, from who is subject to the, let's see, Burkina Faso. Burkina Faso is subject to the full ban. You can't come. But let's say you also carry a French passport in addition to your Burkina passport. You can come into the US with your French passport. So that's how it's going to work. And let me read out the countries that are subject to the partial ban from Africa and the African diaspora. We have Angola, Antigua and Barbuda, Benin Republic, Burundi, the Cote d'Ivoire, Cuba, Dominica, Gabon, the Gambia, Sierra Leone, Malawi, Mauritania, Nigeria, Senegal, Tanzania, Togo, Venezuela, Zambia, and Zimbabwe. These are the countries that are subject to the partial ban. They, they may come. I think they can still get immigrant visas, but they cannot get no more tourist visas for a while, no more student visas. The F, the M, and the J visas will not be given to people from these countries. Although they do say that they'll make some exceptions. If you ask, in fact, on a case-by-case basis, they may accept you from this ban. Maybe you can show them something that shows that you really need to come to the US and that you also show them that in the opinion and they have to run it through a system whereby either the Attorney General, the US Attorney General, or the Secretary for Homeland Security or the Secretary of State, if they can say that you're not going to be a security constitute harm to the US, they may allow a case-by-case grant of those visas to people from those countries. I hope I'm making some sense, and I don't know if you're understanding. So, for the full bans, nobody from those countries can come. For the partial bans, it looks like immigrant visas can still be given, but I don't know for sure. I'm relying on like anecdotal evidence. Non-immigrant visas will not be given if those visas are for students, FMJ. So that means that the business side visas can still come. A Senegalese, no. I'm looking for a country that has I'm looking for a country that, if your country, for instance, has the e-visa with the US, you have the e-visa treaty available to your country, you can still come. You can come with the L visa if you qualify, but not just the B, the tourist visas and the student or training visas. They also said, like if for they'll make exceptions also for people who are coming for the World Cup, which is going to happen, I think, later this year. And of course, the Olympics, they said, which makes one think that they plan to make this thing run for a very long time. They will allow athletes to come. They will allow people in the athletic teams, the football teams, their coaches and other support staff. They will allow direct, immediate family members of those people also to come. The players, I guess, the coaches, they will allow them to come. Fans will not be allowed to come. So if, let's say I think the Senegalese team has qualified, there'll be an exception will be made for them. I don't know for sure, but let's say the Senegalese team has qualified. The team members, I'm not sure really what will happen. Okay, we're using Senegal, yes. Senegal for the partial ban. So let's say Senegal has qualified for the World Cup. They will allow the Senegalese players to come. They will allow the Senegalese coach and other supporting officials. I guess and I'm almost sure they will limit the number of supporting roles to come. They will allow, so supporting roles could be Senegalese-born referees. They will allow their family members, this group of people, they will allow their family members to come, but just your regular Senegalese football fan who just wants to come and watch the World Cup and cheer their country, it's not going to come unless you're not allowed to come unless I guess you can. That case by case exception is made in your case, and people can still apply for asylum. So for those who want to apply for asylum, even if you're in the restricted country or the fully banned country, you should still be able to apply for asylum. And I believe the reasoning for that is that asylum applications and grants have a flavor of international law to them. If you're running for your life, international law says if you run into this place, they should process you for asylum and see if you qualify to be given asylum. So you can still apply for asylum. Whether you'll get it, of course, is up to the government. So that is it about the bans, the partial and the full bans. Then the next thing I will talk about will be how removal proceedings are happening. Or maybe let's talk about bond and detention first. So bond and detention, because of the new policies of President Mr. Trump, what's going on? People are being swept up. We've seen what happened in Chicago. We've seen what happened in Minnesota, in Maine, and indeed in other places where DHS agents are there. They've been hired. They're just hiring and quickly churning out trained agents, and people are being arrested. What we have noticed is this. It used to be you're arrested in a place. Let's say you're arrested in Atlanta. They transfer. They have like for every field office, they have their areas where they detain people. And normally it used to be that if you're arrested in Atlanta, you go to one of those Atlanta area or Georgia area, Atlanta centers which are used for detention. However, what we're seeing these days is that they just arrest a person and send them somewhere. Recently, I had a case of somebody who was arrested out in New York. She was sent to Texas. She was sent to somewhere outside of San Antonio, Texas. So when they do that, it makes it very difficult to communicate with your client, because if my client is in the Atlanta area or somewhere in Georgia, it's easier at the most, maybe 2-3 hours drive, and a lawyer can go over there and see their clients. Now it's more difficult. Can you imagine going from Atlanta to San Antonio to go see your client? It adds on costs. And this makes it difficult for a detained person to have representation, which is, of course, what they want. And then in that case, clients are people who are detained. Some of them are reporting that they are being forced to sign, like a self-removal consent to being removed without being run through immigration court. I've actually heard of a person who told me, hey, in his detention center, people are being told that somebody was put in solitary because he refused to sign. People may be put in solitary. So things are going on there, and It's the whole idea is to round up as many people as possible. I know they said it was going to be only the worst of the worst. No, only people with criminal records. But I'm telling you, everybody is getting picked up. People who have criminal records, people who do not have criminal records. I recently dealt with a case of a lady. She had an asylum application pending, no criminal records. They just caught her and took her. And, we've been able to, so that's what's going on with those people. She was lucky enough not to be forced. She had some personal reason, and for some reason, they couldn't get her, transport her out of the place where they detained her. So she was lucky that ways, but a lot of people are not lucky that ways. But once the person has been arrested, you have the right to ask for bond. Bond is still being given, although sometimes you get a bond and it might be in an amount that just looks impossible for you to pay. Or sometimes you get bond and the DHS appeals, which kind of throws things out because once they appeal bond, nothing really can happen for 90 days on your side. But bond is still being given, which is sad, but like I've always said, whenever they start doing something, the government starts doing something, immigration lawyers always respond. So they're just responding more vigorously. Personally, I had said I wasn't going to immigrate. I hadn't been to immigration court in a while, but last year I was like, no, I actually view this as a bit of a calling. So I'm back there doing my best, doing my little thing to contribute and help as many or as few people as I can manage to help. So we'll request for bond. But earlier on, they started as saying this, that, oh, those who came in across the border cannot are not eligible for bond. Meanwhile, the immigration law has its own people. They have a list of people that must be detained. That's what we call mandatory detention. It didn't include people who just walked across the border. So there was a case which the BIA said that, well, if you walked across the border, you're no longer entitled to ask for to be granted bond. But once somebody appealed it or petitioned for review, and the one of the district courts, I believe in the Ninth Circuit, so that should be out of the California areas, they said no. They reversed the BIA. They said those people are still qualified. However, how that case is not binding on the whole nation, but what it will do for everybody is that lawyers can now build on the argument given in that case and hope to secure bond for their clients who might have just walked across the border. Does this affect us? Normally, we think it's only South Americans who walk across the border, but I also know that there's people who sometimes, as they are fleeing for whatever reason, they land in South America and they walk across the border from different nationalities. So that's also important to us in Africa and in our African diaspora. So that's it about bond. Then in actual immigration hearings, the very same thing, because people are moved across to places where they don't normally live. You go, so once you're taken to you're detained in a particular place, it's the judge in that particular place, is the immigration court in that area, which will hear your case. These days, there's a dichotomy between people who's in immigration court, between people who are detained and people who are not detained. And the non-detained cases seem to go to some courts, and then the detained cases, you may find that there is an immigration court in the detention center, or the. But one good thing that's going on that is the immigration courts now have online-based hearings, and that has allowed lawyers to be in their offices, log on to the internet, and take part in immigration court hearings wherever they use WebEx. So that has really been, I guess, a good thing. They started phasing that in even before COVID, but I think after COVID it just took off, and now they may have found it's good for them, and it's also good for all of us. So you can basically help more people. For instance, I can help somebody in New York. I'm just sitting in my office. I can help somebody in California sitting in my office. Before this would have meant flying more expensive. So that's good. Um, But in removal proceedings, I'm finding that judges are insisting they've been given timeline within 1 month. You must do this, you must do that. So they are rushing to get people ordered removed. People, on the other hand, also responding. If you have a case that's pending, let's say, for instance, your child or your spouse has applied for a green card for you, you can ask the court to please wait while let me get a decision on my green card. Because if I got that petition decision and it's favorable, I'll be able to apply for a green card. Of course, all other things being equal, if you make that kind of an argument, you're possibly going to get a stay. In some cases, trial attorneys have even intervened and helped ask for an expedited decision in the pending petitions. If you can get that done, excellent. Otherwise, they're not the immigration court judges are no longer being patient with the petitions that might take a longer time to adjudicate. Like, sometimes you file something in court with USCIS and there's a long wait. The judges don't like that. So these days, people will use visas, T visas. If you don't have your bona fide determination, the courts will not like, the immigration courts are not waiting. They'll tell you to go. They're more likely to order you removed. Of course, you can appeal, but that's what I'm finding out. I think lawyers are finding out. Um, Again, lawyers are also being creative. There's always some kind of creativity going on about how to fashion your case so you can get bond, and also so you can keep your removal proceedings alive and see if you can get your benefit. Then if you're proceeding, you're removed, you've been ordered removed, something entirely new is going to be happening as from March 9th. That's in about 10 days or so, plus minus. The BIA, the Board of Immigration Appeals, has changed some rules internally. And they say, normally they have shortened the your time to file a notice of appeal from immigration court to 10 days. Used to be if your court, if the immigration court denies your case, you have 30 days to appeal. Now they've shortened it to 10 days. Again, we're already dealing with increased filing fees. It used to be $110 to appeal to the BIA. Now it's over $1,000 to appeal. It's about 1,100 or so to appeal, or I think 1,030 or 1,100 full to appeal to the BIA. So these things are discouraging, making it difficult for people to appeal to the BIA. And then you now have 10 days. And not just that, the BIA says they will automatically dismiss an appeal from the immigration court if a board, if the BIA board, the entire board, does not vote to allow that appeal. So it used to be that once you file your appeal, somebody will, sometimes it's the three-judge panel that will listen to your appeal, listen to your appeal. Sometimes it's just one judge. But never has it been that there was another thing, there was another hurdle, if I may put it that way, to scale. If you filed an appeal, you're going to get a decision. You're going to get your case considered. Now they say, as from March 9th this year, your appeal to the BIA will not be considered, except if all of the judges all vote to consider it. If the judges can't agree to consider it, it's going to be dismissed. You're stuck with whatever the immigration judge says. And there's no wisdom. Nobody has all wisdom. So the immigration judges, I guess this empowers them to give decisions like they want, and somebody is going to be, you're not going to get any recourse at the BIA. Another thing they've done with the BIA is this. Normally, if you file, then you write your legal brief, which is your legal argument. You file your legal argument, and then 21 days later, ICE is meant, trial attorney, that's DHS, is meant to file their briefs. Now they're saying when you appeal, both briefs will be filed at the same time, which doesn't make a lot of sense to me, because normally the DHS, which is on the other side, we should get an opportunity to read your brief and then reply to your brief. And you can even file a further reply brief yourself. How can the DHS file a reply brief when they haven't even really seen the brief that the respondent is filing, the foreign-born person is filing? So it doesn't make sense to me. And of course, we lose the opportunity. The foreign-born person loses the opportunity to file a further reply brief. So this is sad. But one thing for sure, this one looks like it's a very blatant due process violation. If you look at it, that's not how due process works. So my thinking is that this rule will not stand. I'm sure that come March 9th, March 10th, March 11th, March 12th, lawyers are going to do what? They're going to start appealing to the federal courts of appeal, to the U.S. The circuit courts of appeal. We're going to go there and clog up those courts with the kind of cases those judges don't like, and which involve those immigration cases, which involve, and you're looking at very serious due process violations from rulemaking, from just something internal U.S. Internal policy and not rulemaking. They're not going to like it, and I have a feeling it's going to be struck down. I hope, who knows if it's struck down, they may appeal to the Supreme Court, which is all very dicey these days. But my opinion is that this will not start. So, clearly, as usual, the first few people may get caught up in it, but I don't think this is going to last. And then the next thing is, this one's a little nice, something good. It's from the EB1, the Employment-Based Green Card series. You know that I think a lot of us are aware of the EB1 cases where a person can self-petition, you petition for yourself for a green card if you're a person of extraordinary ability. So lately, from the first, from a district court in Nebraska, and then this being that it's a district court, it's not of national application, but what's going to happen is that other lawyers are going to quickly catch on and start making the same arguments and hoping to get the same decision from USCIS. See what happened in that case. There's a case called Mukherjee versus Miller. Mukherjee versus Miller. In that case, this district court in Nebraska made a ruling which really does help people who are applying. What we've been saying up till that day about 2 weeks ago was that if you are now a petitioner, an EB1 petitioner, the USCIS will evaluate your case using two steps. Number one, they look at, do you have 3 out of those 10 awards that they ask? They ask you to 3 out of 10. If you don't have a big prize like a Nobel Prize, they'll tell you, okay, look at these 10 criteria, pick 3 out of them, show us you have those. If you can meet any of those, that's fine. Not just those 3 out of 10, they have also, then they will take a total look at the file, at your case, and see if you really have extraordinary ability and sustained recognition. Well, this district court in Nebraska looked at USCIS and said, you've been applying the wrong standard. The standard you apply doesn't have a basis in law. And you're applying it outside the requirements of the Administrative Procedures Act, the APA. That is really the APA is the base of all due process. A lot of due process claims are based out of that. And the process here seems to be this rulemaking. Whenever the USCIS wants to make, there's laws, there's the Constitution, then there's laws, the federal laws, then there's regulations. We flesh out how the laws should be applied. So each time a regulation is good, before a regulation is meant to be enacted, there's a public, sometimes 30 days or 60 days, there's a public hearing period when the public, the US public, is allowed to write in and say, see, this is your proposal. I don't think it's going to work, or why don't you do it this way? They make suggestions. It's actually open. So for the USCIS to be making adjudications based on their own internal guidelines and policies and not the rules, the regulations, which are properly ordained by law, the court held that that's what's been going on when the USCIS has been looking at this as EB1 cases, and that's a wrong standard. It's not a legal standard because it violates due process. So they sent that case back, Mr. Mukherjee, or I think it's in Miss Mukherjee's case, they sent it back to USCIS and told them to approve her case. That means that second thing, that second factor, which the USCIS has been using, which is to say, to look at the totality and see if the person has extraordinary ability and sustained recognition is not allowed. It's unlawful because it wasn't properly enacted. USCIS is using that standard based on their own internal decision to do so, not based on regulations which are enacted properly under the law. So if basically the court was saying if she has met 3 out of the 10 factors, there's no other examination, there's no other hurdle to be met. You give her EB1 application. So that's a good thing, meaning that going forward, you can when you're applying for your EB1, you can look at that Mukherjee case and kind of follow it closely, the arguments there, and use that argument made by the district court to USCIS, and you can even hope to get an easier approval of your EB1 case. It should be approved because you've met the standard. Like I said, it's from a district court and it really doesn't cover it doesn't automatically cover the USCIS, but you can now do it. And people are now trying to also reopen their old denials. If you can read your denial and see that you can match it to this case, the Mukherjee case, you can actually ask that your case should be reopened and you should be approved. And so that's something good because I know that these days, a lot of our people were relying on the EB1s, the employment-based green cards, and see how it will, how it will work. So let's say you're from any of the countries from the partial ban, you may find out that this may be a way for, this will help you. So I think that's all from my academic part of it. Personally, what I'm seeing is just people reporting, oh, well, they have not been able to, their green cards have been delayed. Yes, they're being delayed, processing of them being delayed just because they're just looking extraordinarily close at that applications. But lawyers are suing, and I know some of them who will sue over who have made class actions for denials. Because of this country ban, Nigerians, even some people, and when I say Nigerians, because it's the country of a client I have experience with. I know somebody, a client, he got his naturalization approved. He was basically pulled out of the line. Couldn't go to naturalize that day. Couldn't get to go to get sworn in that day. So what was done was I told him, hey, there's somebody who I know is suing for people on your behalf. You qualify. So if you have somebody like that, or if this is your position, you might be able to sue them and force the USCIS to naturalize you. Certainly, I have another of my colleagues told me of a case of the person from, I believe, was Afghanistan, and everything was ready. They pulled him out of the line and they wouldn't naturalize him. So he sued the USCIS in federal court. And like I told you, the federal courts, the Article 3 courts, the judiciary courts in the US, they don't like these, if I would call it shenanigans that USCIS, the executive plays. So he says that they were out there, they were sitting in court and their case is called up. And the judge says, what's going on here? So, well, my client is meant to be naturalized. He's passed everything, but he was pulled out of the line because of the USCIS. He says to the government lawyer, so what is going on here? Why the government lawyer stands up, oh, well, they are doing this and they're looking at, and the judge said something basically like, where's the client? Where is this person? He says, point him out. He says, stand up, raise your hand. I swore him in. And that shows us, and this is a real thing, it was a lawyer that narrated this. So that tells us we have to be bold. go ahead and sue the government because you can win. And then that's how you make law and you clear way for yourself and other people like you. You get what you need to get. So I'm encouraging people. And also another thing, as always, because of this Mukerji case, we see I see the importance of people taking part in the rulemaking process. I'd have to say that I've never gone to contribute to that, but I guess shame on me. But going forward, I plan to. Anytime I hear rules are going to be made, I'm going to go ahead and go to the rulemaking that portal. There's a portal called regulations.gov. Regulations.gov. You go there and you can find rules which are being proposed. If you have one in mind, you search for it and you can contribute, give your opinion as to whether you think this rule is good, whether you don't think it's good. This is the reason, and you can even make suggestions. So I think this is where oh my, wow. We don't have that much time for questions, but please ask me.
All right. Thank you again, attorney. Always insightful again as usual. Please, if you have any questions, you can unmute or feel free to use the chat if you have any questions for our attorney that we can answer in a public forum. Have any questions, whether it's for yourself or somebody you know who's going through something, what's the best approach?
Oh, is everybody just sad? We have this thing take some time. It's really saddening, even for lawyers, because
Yeah.
you don't have sometimes you don't have good news. But really, you must fight. There's always some kind of fight to be put up, and we must keep our spirits up.
Yeah, so well, Attorney, thank you so much. You definitely help us. I think information wise, it's good for us to at least stay informed. I will continue to do this. And so, in the spirit of information, AIM is also taking our another first step. I think today is the day of first, so we were taking another first step, a major step in our maturation as an organization that's really given to serving our community. And this is a big one for us. One of the reasons why I really wanted our attorney to go today was so that I can make this announcement following her session. But starting next Saturday, every first Saturday of every month, we will be having our immigration clinics. Yay! All right. All right. And so, what exactly is immigration clinics? So we have forums like this masterclass series where attorney will come and speak on a topic, and then people can ask questions, but typically it might not address exactly that particular thing you want, or maybe it's something that you're going through personally, or you know somebody and there's no way to, tell the whole full story. But during those sessions, you will have your one-on-one time with the attorney, and you get to talk about your issue. So it's literally free consultation, free legal consultation. Attorney sessions are not free, but this time for AIM, she's giving us she's giving us time, and it's free for those. At least you get direction and clarity on the route to take. So that is what the immigration clinics will be. So please spread the word. Don't keep it to yourself. Don't gatekeep the information. We don't have a massive marketing budget, so how we get the word out is you tell people that, hey, this is happening. I put the link to join the WhatsApp community on the channel. That's the easiest place for people to stay informed. So invite people you know to join our community on WhatsApp so that when the information on how to book your session goes live, you know what to do. So every first Saturday, it's going to be from 10 a.m. to 12. 12 so 2 hours, 10 a.m. to 12 p.m. and it's you get your small time slot there in that time frame. So please help us get the word out and we want to serve as many people as possible. We'll be starting, there'll be virtual sessions to start. But our prayer and our hope is that in as we continue, we'll start finding partners and we will once every quarter, our goal is to have an in-person session where we'll get, right now we have Attorney Uzo, we also have Attorney Cassandra. We're trying to get other attorneys on board to um, to also to expand our pool of attorneys just for this purpose, so that we want to be able to go to community centers, schools, churches, and have these sessions in person, at least once a quarter, and then people can come out and have their sessions, or have questions answered, and they get to talk about their cases. So that's a big thing for us. That was something that we had in mind, and then it was brought up again during our town hall, in last month. And true to just our commitment to serving, we initiated action, and today we're here. And I really want to extend special thanks to Attorney Uzo and Attorney Cassandra for just saying yes to, and sitting down and really crafting how this will go. So more instructions will come. We'll put out announcements on how to book sessions next week. We'll keep fine-tuning the process as we continue in subsequent months, but we're starting, and by God's grace, we'll continue. It will continue to grow and expand, and more people will be served through this platform. All right. Also, next month, end of the month of March, so in fact, in exactly a month from today, March 28th, we will be having our women's conference. Last year was incredible, and this year it is also going to be powerful. I think the team is, women that open doors, something like that. It's a very fancy, powerful title. I'll put the link on Eventbrite. Please go register and invite people. Help us spread the word. That is the biggest thing you can do for us is tell people, be an ambassador for AIM, let people know what we're doing. A lot of work goes into putting these things together. The best way you can tell us we're doing a great job is by bringing people to join the WhatsApp, to attend the events. That is the support one way to support the work that we're doing. So please spread the word, help us get the word out. But for all the women on the call, go ahead and sign up, and then take the link with you, copy the link, and share that. Let's distribute it widely. And then the last announcement I want to make is last year we started becoming more vocal about asking for donations, and we will continue that until. But one push I am making, for again, I'm seeing some people here who have given to AIM before. Thank you very much to everyone who has made a donation. I'm putting the link back. My ask now is that we consider being recurring donors. So instead of just your one time $20, can you make that be a monthly thing? The reason we're asking for that is if we have 10 donors giving us $20 every month, we know we have a budget for $200 a month. If we have 20 donors, it gives us a way to plan, right? So we do programming, we do events. We know it helps us be able to plan these events, these programs, the things that we do. So please take the link, think about it. If you need to have a conversation with your people to know what's within your capacity, again, $20, $50, 100, 1,000, whatever you're able to do. It will go very far for us, but we want to encourage everyone, just again, that recurring monthly donation will do us a lot of good. So that's my ask and appeal to everyone. So please take the link, go ahead and sign up and become a donor with AIM if you want to see us continue doing what we're doing. But that's it for today. We are right on the money. It's 2:58. Once again, thank you, Attorney Uzo, for your time.
My
Um,
pleasure.
Francesca said, I'm licensed psychotherapist. We're glad to assist when in court. Please send me. Are you on our WhatsApp? Francesca, are you on our WhatsApp? I'd love to have a conversation with you so that we can find a way to structure it. Let me put my number on the chat. Please send me a message, 334552138. All right. If you can send me a text, please I'll take your number as well. Sorry, so that we can let's have a quick conversation so that we can properly plan and see how we can also get you collaborating with attorneys. All right. Well, thank you so much for your willingness to support there. That's the power of community. That's how community works. Everybody bring in their own ability and then able to help us keep moving this along. Well, thank you all so much. So we're back again. So next week will be, please look out for the announcement for next week's session. Well, next week we're likely going to be, it's probably going to be the immigration clinic, 10 to 12. And then if we do have, Chika, any free consultation? I feel like we're not giving you free consultation. We'll verify. You're going to adjust the statement, exception, Chika. Well, please, once
Oh,
we send, we're going to send out the link, hopefully by Tuesday to book the
okay.
session. So please make sure you go ahead and book first.
I
Since you're on the
I will
inside,
do
you
that.
probably see it first. So, but I
Uh,
want to appreciate everyone again. Thank you so much. The replay will go live normal, I think on Tuesday. We're back on schedule, so please look out for that. We'll post that in the community internally and then distribute it widely as well once it goes live. But I'll let you all go. Thank you all. Have a blessed rest of your day, and we'll see you all next Saturday. All right. Thanks, everyone.
Bye. Thank you so much for